Welcome, everyone, to the Ontario Caregiver Organization's webinar series. These webinars bring together caregivers and subject matter experts to explore topics of interest to caregivers. And we do this to support and engage chosen family, friends, or neighbors who are caring for someone in their lives. My name is Hannah Albany, and I will be your moderator today. Before we begin, I would like to take a moment to acknowledge the lands that we are on today. While we meet on a virtual platform, I would like to take a moment to acknowledge the importance of the land we each call home. I am joining you from the city of Thunder Bay, which is located on the traditional territory of the Anishinaabe people and the lands of the Fort William First Nation, signatory to the Robinson Superior Treaty of 1850. I also want to acknowledge the ancestral and unceded territories of all First Nations, Inuit, and Métis people who have called Turtle Island home since time immemorial. This acknowledgement is part of OCO's ongoing commitment to reconciliation, to building respectful relationships between nations, and to exploring how we can be meaningful allies. It also reflects our support to the calls to action of the Truth and Reconciliation Commission. If you would like to learn more about the land you are joining from, please visit native-land.ca. It's a helpful resource for exploring the Indigenous territories, languages, and treaties connected to your location. Our webinar today is called Understanding Legal Information for Caregivers. Legal terminology can be confusing, but it is essential for caregivers to navigate the healthcare system. OCO is pleased to welcome Kate Dewhirst, who will explain key legal information that caregivers should know. In this webinar, we will go over important legal terms such as power of attorney, consent, capacity, privacy, and substitute decision makers, and the scenarios which you might encounter them, along with how they apply to your caregiving role. We will also cover how to effectively explain legal situations to your care recipient, ensuring that information is communicated clearly. And we will also share practical tips and takeaways to enhance your understanding. Please note that today's webinar is for general information purposes, and we will not be able to answer individual legal questions. Our speaker today is Kate Dewhirst. She is both a lawyer and an educator. And for 25 years, she has provided legal advice to healthcare organizations and taught at universities, as well as through her own training company, focusing on health law topics. Her mission is to make the law accessible and engaging. She enjoys simplifying complex issues and making learning enjoyable so that people feel more confident in their understanding. And without further delay, I will turn it over to you, Kate.
Thank you so much, Hannah, and I'm thrilled to be with you all today. As Hannah mentioned, this is just for information purposes only. I cannot be offering legal advice during this session, but I hope that this is helpful information. Our goals today are to explain important legal terms that you as caregivers may hear from time to time. I also want to identify the scenarios when you might be asked, who are you in this environment and why that matters. I want to also offer up some tips for how you might explain who you are to healthcare providers and how you can work with and for your care recipient. I'm going to start off with the key terms. What are some of the key legal terms that you need to know as a caregiver in Ontario? Care recipients are people who are receiving healthcare or service in Ontario. Other words we might use are patients, clients, residents, consumers, or service recipients. But for the purposes of this webinar, I will use the term care recipient. Providers for this webinar are healthcare practitioners, organizations, residences, and programs who provide healthcare and service to care recipients. I'll use the term caregiver to describe you. So, caregivers, for the purposes of this webinar, are people who provide physical and emotional support to a care recipient, who is your family member, your partner, your friend, or maybe a neighbor. Some more key terms that we need to understand and just think about right off the top. One of the words is consent. So, this is a legal word, and it means giving permission for something. And when you give consent, you can choose to give it or not give it. So, consent means that you give permission to do something or you choose not to give permission for something. You can also change your mind, which is called withdrawing consent. So, consent is giving permission for something. For the purposes of this webinar, we're talking about a healthcare decision, such as treatment, counseling, admission to a care home, might be a long-term care home, or personal assistance services, such as oral care, bathing, dressing, or assistance with medications and mobility. So those are all thinking about healthcare decisions. Another reason why consent may be asked for has to do with privacy decisions. So in that category, I mean collecting information, or when a provider is using health information or sharing it, disclosing it about a care recipient. It also includes having a copy of health records, and that might come up for you from time to time. It means also sharing information with other care providers, insurance companies, or police. So that's what I mean when I'm talking about privacy decisions, includes all that information sharing. Another word we need to think about is another legal term called capacity. This may not come up for you a lot, that people may not talk about capacity, but this is something happening within the care providers' decision making. They are making decisions about a care recipient's capacity. What does it mean? It's a legal term for the mental ability to make decisions for oneself. So there will be terminology that gets used, sometimes verbally or orally, but lots of times in the health record itself. You may see words like capable or incapable. I want to explain what that means. If a care recipient is capable, they are legally allowed to make their own decisions about privacy and healthcare, or just privacy or just healthcare, or both. So that's about being capable or having capacity. Another term is incapable, or not being capable to make your own decisions. So if a care recipient is not capable, they will need what is called a substitute decision maker. And that is the person who will make privacy and healthcare decisions for them. So now that brings me to another term, substitute decision maker. There's so many different ways we talk about this, but this is a legal term that gives legal authority to a person or to a group who then has the right and the responsibility to make healthcare and privacy decisions on behalf of incapable care recipients. So this is a legal term. Sometimes people don't use the correct legal term, and that can lead to some confusion. So if you have ever been confused about who is supposed to be making decisions, it might be because care providers don't necessarily use the right terms, or you had never heard of this term before, and this is the first time you're hearing about it. But the right, correct legal term is called a substitute decision maker, or the acronym is SDM, substitute decision maker. So I want to just pause in my sharing of what all these words and terms mean, and I want to go a bit deeper in what is a substitute decision maker, because from my experience, there's so much misunderstanding of this term that it really will help us to dive a little deeper. Who can be a substitute decision maker? So, in the case of healthcare, if someone other than the care recipient is going to make decisions, the healthcare providers need to know who can do that. So there may be a bunch of people putting up their hand or saying, I want to make decisions, or they may be just offering up their input, their thoughts about what should be happening with care. But it's actually an obligation on the provider to know who is making the decision. Is the care recipient incapable to make their own decision? Then we need to find who is the substitute decision maker. Is it one person or is it a group? So what you might hear from time to time is that substitute decision makers, or SDMs, stand in the shoes of the care recipient. When a care recipient isn't able to make their own decisions, the care providers need to find someone to stand in their shoes, meaning whatever the care recipient would have been able to make as a decision on their own, someone else does that for them. They stand in their shoes. So let's go over what does that mean to really stand in the shoes of another person. What kinds of activities, if the care recipient is not able to make their own decisions, what can a substitute decision maker do? They can do these things. They can make privacy decisions for the care recipient who's incapable. They can give consent, but they can also not give consent. They can refuse consent for sharing a care recipient's information with other healthcare providers. They can ask, so a substitute decision maker has the right to ask for a copy of the care recipient's health records. And then the substitute decision maker can share that information how they choose with the people they think are important to have a copy of that health record itself or the information from that health record. A substitute decision maker can also give or refuse permission to release a care recipient's information to someone else, like an insurance company or a landlord or some other friend in the community. A substitute decision maker also can ask providers to keep other caregivers updated. Let's remember that for future parts of this webinar. A substitute decision maker can ask providers to keep other caregivers who do not have legal authority to stay updated about the care recipient. Or the substitute decision maker can also approve information sharing with those other individuals, those other caregivers. However, we have to also be thoughtful and practical about providers' time. It might be that providers ask that there be one person with whom they share information, and that person then updates the whole community around the care recipient. So you can ask for other caregivers to be kept up to date, but sometimes practically it may be one person gets information and then that person is understood to keep the rest of the caregivers updated. Substitute decision makers can also ask to bring additional caregivers to meetings or appointments with providers. They can give or refuse permission for research activities. Substitute decision makers can ask that health records be corrected or changed to reflect the realities of the care recipient. They can also make complaints about privacy practices. Now, substitute decision makers also make decisions about treatment. Substitute decision makers make decisions about admission to a long-term care home. Substitute decision makers can make decisions about personal assistance services and devices. So when a care recipient connects to a healthcare team, if that care recipient is incapable, the healthcare team starts to look around. Who is the substitute decision maker? Is it one person or is it a group? Sometimes the healthcare team is presented with the people who show up. And those are the people who are said to be the substitute decision makers. That is what is expressed in a verbal conversation. Sometimes the care recipient themselves or the people around will have documents to say, hi, I'm actually the substitute decision maker. But in a lot of situations, there is no documentation, and nobody has come forward to say, I am the substitute decision maker. And so healthcare providers who are looking for a substitute decision maker for an incapable care recipient, there's an automatic list. So in law, under the treatment law, under the admission to a care facility law, under the privacy laws for healthcare professionals, there's a list of who can be a substitute decision maker. So this list is very important for you as caregivers to know that it exists. This is what we call a hierarchical list. What does that mean? It means we start at the top at number 1, and we keep going down the list until we find somebody who is in that category. So the people who are, if we have a number 1 guardian of the person, that person will outrank anybody else lower in the list. Now, let me go through this list of who can be a substitute decision maker, and you will reflect on your own circumstances involving your care recipient. Is there someone else who is higher up than you on this list? Are you on this list? And where do you fall? So we start up at the top, a guardian of the person or a guardian of property. This is a legal document. So you'll see 1, 2, and 3 are shaded in blue. If you can see colors that's shaded in blue, these require a legal process. So there will be a document that says a person is a guardian of the person over the care recipient, or a guardian of property for the care recipient. You don't have to guess. There's been a legal process. There's a document for that. There are very few guardianships in Ontario, so most people have never heard of this. It's not applicable. So we move to number 2. An attorney for personal care or an attorney for property. That also requires a legal process. The care recipient had to be capable to issue a legal document. Just in the next section, I'm going to explain what is a POA, power of attorney, but that's what we're talking about here. In that document, it will set out the authority of the person to make decisions for the care recipient. In the absence of that, we look to see, is there somebody who has gone to the Consent and Capacity Board of Ontario to become a representative appointed by that board? You may have never heard of this, but there is something called the Consent and Capacity Board. And if there is confusion in the light pink category lower down, people can go to the Consent and Capacity Board to ask to be made a number 3, a representative appointed by the Consent and Capacity Board. So very few people utilize that whole process, but that is available if there is friction or family confusion about who is going to make decisions. It is possible to engage the Consent and Capacity Board to appoint someone to become a representative, and then that person would make decisions for the care recipient. A guardian or a power of attorney document would outrank a representative, but a representative appointed by the Consent Capacity Board outranks any other family members without legal authority. Now, in most circumstances, for most people receiving healthcare, there isn't any of the 1, 2, 3. So decision-making for an incapable care recipient often falls to someone in the family. And there are legal terms for who is in a family, and they are ranked in this order: a spouse or partner. And then number 5 has a bunch of different people in it. The children of the care recipient, they're in number 5. The parents of the care recipient are in number 5. And then there's also a role if the Children's Aid Society is involved, if the care recipient is a child, and if that child has been taken out of the care and decision making of parents and the Children's Aid Society is involved, that's where you will find Children's Aid Society decision making. After that is there still is a role for a parent who only does not have any decision making authority, but has a right to visit and see the child. That's where a parent of that relationship would be found in decision making. Then brothers, sisters, or siblings are at number 7. And then there's a bucket of any other relative. So that's very broad, understanding any kind of relative to the care recipient. Now, number 9 is the Office of the Public Guardian and Trustee. So that is a substitute decision maker of last resort. That means no matter what, if a care recipient doesn't have any family or there isn't anybody on this list, there will still be someone who will make decisions if the care recipient is incapable. It's called the Office of the Public Guardian and Trustee. Now, something else to know about this list is that everyone who's in the same number on this list are equally authorized to make decisions. So if in your situation, your care recipient has a spouse or partner, they're at number 4. If they have children, those children are at number 5. The spouse would outrank the children. If there is no spouse, and there are many children, all the children of the care recipient would be found at number 5. So one of the things that we have to keep in mind in this webinar is that all people in the same numbered category are equally substitute decision makers. But if there's someone above them on the list, that person would outrank, the number of people underneath. Now, they also have to meet certain criteria. So to be a substitute decision maker still requires criteria. So you do have to be at least 16 years old to be a substitute decision maker. There are some exceptions. If a younger person is the parent of a child, they can be that child's substitute decision maker. But otherwise, you have to be at least 16. A substitute decision maker has to be available. So if they're not available by phone, if you cannot reach them, then they're not able to be a substitute decision maker. They also have to be willing. You can't make someone be someone else's substitute decision maker. And that can be really ethical, and for you as caregivers, you may feel like, I don't really feel like I have much of a choice. I feel this burden of being a decision maker. That is something that we can talk about. That is a real experience for many people, but in law, the substitute decision maker has to be willing. And we'll talk about a scenario of that in a minute. A substitute decision maker still themselves has to be capable. So remember, capable is a legal term meaning the mental ability to make decisions relating to that healthcare choice, that privacy choice. So to be a substitute decision maker, then you also have to be capable to to have the ability to understand the information that is relevant for the decision and have the ability to appreciate the reasonably foreseeable consequences of the decision. And that's really the test for capacity. So if someone is capable, they have that 2-part test. They are able to understand the information about the decision. That's an intellectual part. And they also have the ability to appreciate what possibly could happen. That's a judgment call. That's a maturity aspect of decision making. So that's the 2-part test for capacity. And substitute decision makers also have to be in that category. They have to be capable. They also cannot be prohibited by a court order or a separation agreement. something restricting their access to the care recipient or decisions about the care recipient. You can imagine if there's a circumstance of domestic violence, and if otherwise the spouse or partner would be the substitute decision maker, but there's a court order or a peace bond limiting access to the care recipient, then that person is no longer able, they don't meet the test requirements for being a substitute decision maker. So there's a few more terms I want to explain about substitute decision making. A spouse is defined in laws relating to decisions about treatment or decisions about privacy, is someone who is married, someone who is living in a conjugal relationship outside of marriage, and they've cohabited for at least 1 year, or are the parents of a child, or have a cohabitation agreement. A person is not a spouse if they're living separate and apart as a result of a breakdown in their relationship. So once people split, that right to sit in the spouse category goes away. Once they split, and even if they're not fully divorced, they lose that right to be in the spouse category. A partner is defined as either of two persons who have lived together for at least 1 year and have a close personal relationship that is of primary importance to both persons' lives. A relative is very broad, includes someone who is related to another by marriage or adoption. So broadly relative, and then also inclusive of marriage and adoption. Let's go over what is meaning of POA. You're going to hear POA all the time. In fact, you may have said that you're POA, thinking that that means that you have decision-making authority. But POA, that acronym, stands for power of attorney. To have POA, power of attorney, you need to be named in a document. And that document is called a power of attorney for personal care or a power of attorney for property. Personal care relates to healthcare decisions, also personal assistance decisions, and also having admission to a long-term care home. Power of attorney for property relates to financial decisions, selling a house, making financial purchases, real estate decisions, etc. So the power of attorney document will say whether it relates to care or whether it relates to property. And they may be different people who are in those power of attorney documents. So the person who is named in the power of attorney document is called the attorney for either personal care or the attorney for property. And in this sense, we don't mean a lawyer. It's a term used for someone who is making decisions. So a power of attorney, an attorney for personal care, is a type of substitute decision maker. And if we go back to that list, we find, quote, POA, or the attorney who is making decisions, we find them at a number 2. There was a legal document that was issued. So when we look at that POA document, it may have reorganized the family decision-making authority. If the care recipient, when they were well, issued a power of attorney for personal care document and named their child number 2, that person is now going to be the attorney for personal care. They will outrank the care recipient's spouse, the care recipient's sister, the care recipient's child number 1, because they were named in that power of attorney document. So I'm just going to go back a slide and show you the spouse is at number 4. The other child would be at number 5. The care recipient's sister would be at number 7. But the attorney for personal care is at number 2. So if there is a particular child that gets identified as the power of attorney, they will outrank other people that otherwise would have outranked them if that legal document did not exist. And just again, a note that there are these terms that we use for property as well, but that's not our focus today. So let me now take you in the next 15 minutes through a couple of scenarios. I want to bring this to life. Green flags for you as caregivers, we note it's not a problem. You will have lots of positive relationships working with providers that are supportive of your involvement and give you information, and where you feel like you are a vital part of the team supporting the care recipient. So examples of green flags would be the care recipient is up to date on their own care journey. They have access to their own health information, and they share that health information with you. Another example is you're included in conversations with the care recipient and providers, and they ask for your input. Another good example is you're the care recipient substitute decision maker. The providers know and accept that, and they include you in all care decisions and sessions, and you do make those decisions. You have easy access to up-to-date information about the care recipient. Another positive example is you're not the substitute decision maker, but the substitute decision maker has said that you can have information and you get it. Now, we all know that there are lots of stories where caregivers have not so great experiences in the healthcare system. So, for example, a care recipient has no idea what's going on with them, and they can't tell their caregiver anything. The care recipient won't tell you anything, or you think they're hiding information from you. You want to advocate for the care recipient, but you are told you can't because of, quote, privacy. You are the substitute decision maker, but no one believes you, or you have to prove it all the time, and you're not getting enough information. You are a friend or a family member of the care recipient, but you're not the substitute decision maker, and you find that the substitute decision maker can't or won't share information with you, or you have information about the care recipient that you think is important to their care journey, and no one will listen. So that is what we hear from caregivers from time to time, their frustrations with the healthcare system. So let's just talk about the elephant in the room. Why are there situations where caregivers are not included in receiving information or helping to make decisions? Number one, it might be by accident. We don't have a perfect healthcare system. So we have to acknowledge that. At the best of times in the healthcare system, we have imperfect sharing of information. It might just be by accident that the caregiver didn't get it, or there just isn't anything to share. Again, the elephant in the room is that lots of healthcare system navigation isn't great. We don't have a handout or an explanation of what's happening in general terms or what the care journey might look like. There just might not be something helpful and tangible to share. It's also possible that the reason the caregiver doesn't know is because the caregiver missed an appointment, wasn't able to come with the care recipient. Someone else went and information wasn't shared. It's also possible that to the care team, the care providers, it's not clear who's a substitute decision maker and who's not. And they're busy and they may just not have had a chance to figure it out. So they're not sharing information with anyone. It's also sometimes that it's unsure what care recipients want. Who do they want involved? And we have to acknowledge that a lot of care providers are worried about getting it wrong and making a privacy breach or sharing information. And they don't want to get in trouble for sharing information with the wrong person. They want to get it right. They want to be respectful of the care recipient's information. And they don't know who's allowed to receive information. They don't want to make a mistake. The other thing we have to talk about as the elephant in the room is sometimes a care recipient or a substitute decision maker will say, don't share information with that person. And what if that's you? So sometimes you will not get information because someone has specifically said, don't share it. So when we're looking at from the healthcare provider's perspective, there are a lot of different people who can be making decisions and asking for information about a care recipient. It is up to the care providers to sort through, is it the care recipient who decides or is it someone else? So as a point of access to this conversation, I want to tell you about 4 ways when caregivers can be involved and how you can use tools to assert yourself and insert yourself into the conversations, decision making for your care recipient. So I share with you this decision tree. This decision tree is being used by providers. So in the background, as they're engaging with you, they're thinking about these questions. Number 1, is the care recipient capable? Yes or no? Number 2, if they are not capable, who is the substitute decision maker? And are you, as the caregiver, the substitute decision maker? Yes or no? And if you're not the substitute decision maker, there's another decision. Does the substitute decision maker say that you, as the caregiver, can have information? Yes or no? So I want to share with you some of these examples. And in the green bubbles are ideas of how you can say, hey, I should get some information or I should be involved in some decision making. So let's go through some examples. This is the first one. Before she died, I was the caregiver for my husband's grandmother, and I was her primary visitor in her long-term care home. She had advanced dementia. Her daughter, who's my mother-in-law, was her decision maker, but my mother-in-law lives abroad and was not easy to reach. I never knew what to expect when I asked the care home staff for an update. Would I be told how she was, or told that I had to speak with my mother-in-law when I knew my mother-in-law didn't know? It didn't make sense to me that I was excluded from getting information because I was the only one in the family who had time and could be there to support her. It made everything more complicated, and I worried information was not being communicated properly. So that's an example from the perspective of a caregiver. So let's go to this decision tree. Is the care recipient in this story capable? No. So the next question is the person, this caregiver, are they the substitute decision maker for the care recipient? Also, no. So then we go to the question, does the substitute decision maker approve the sharing of information with this person? And we find in this story, yes, the mother-in-law, who was the substitute decision maker, did give approval. So then the care home has authority to share information with this daughter-in-law. So that is permitted. Now, there may be some other things that we have to think about because sometimes the mother-in-law may not be willing to share information. So from a caregiver perspective, if you hear yourself in this story, here are some tips. You can ask the mother-in-law, your mother-in-law, who is the substitute decision maker, to tell the home in writing that you are the local contact person and that you can receive all information and provide input into decisions. You would keep a copy of that instruction with you, and you could just show it to the staff. It's frustrating, but you may have to show it to the staff multiple times over multiple years. You also may want to keep your mother-in-law up to date about what you observe of your of this grandmother-in-law that you're observing, and keep your mother-in-law up to date. Now, if your relationship with your mother-in-law changes, it is possible that she could exclude you from receiving information. Usually you'll still be allowed to visit, but it may be that information sharing will be limited. The home really should not be asking you to make decisions because there is a substitute decision maker. But remember, the substitute decision maker has to be available and willing. It's possible that if the mother-in-law is not available and willing, that you, granddaughter-in-law, could be on this list, because if there's no one else who's available and willing to make a decision for that care recipient, you're still at number 8. So it is possible from time to time that you could be a decision maker because a relative does include someone who is related by marriage or adoption, and they have to be willing and able to attend. So there's an example. And where we find this kind of situation works, here's an example. A resident, Daphne, with her caregiver, Aylin. Aylin is Daphne's son's wife's mother, so kind of a tangential relationship. Dauphine's sons are her substitute decision makers. Those boys, those men, visit her monthly with their partners and her grandchildren. But it's Aylin who comes weekly to visit. She takes Dauphine outside. They are the ones who are sharing stories. Aylin is assisting with tasks. Aylin often has ideas and information for the staff about how Dauphine is doing and feeling. And Dauphine's sons have said to the home, give information to Aylin. And so Aylin does get information. So there's a way in which it can work. Here's another example. I'm sometimes shocked when I hear my spouse downplay his symptoms to his provider. He says sometimes his pain is a 2 out of 10. Meanwhile, I've just spent 4 days trying to convince the provider to do a home visit for a pain assessment because he couldn't move. He's been in excruciating pain. Now it looks like I've exaggerated, and I'm worried his doctor isn't going to address the pain, and we're going to end up back in the hospital. I feel totally helpless because the doctor said my spouse makes his own decisions, except once the doctor leaves without adjusting the pain medications, I'm going to be the one left here managing my spouse at home. So let's go through that decision tree again. In this case, is the care recipient capable? Yes. The spouse is making his own decisions. So generally, the team is going to ask or should ask the care recipient what they want to have happen. Does he want his spouse involved? And that's when you can say, yes, hi, I'm the spouse. You should involve me. So you have a capable care recipient. You as the caregiver spouse, you don't have legal authority, but your input is valuable. So here are some tips for you. Unless your spouse is incapable, he will make his own decisions and he can decide to include you. And here's the hard part. Sometimes he will choose not to include you. He can decide that everything is shared with you or only some things or no things. And all of that can change over time, depending on what he wants. But absolutely, you can encourage him to have you involved. If you go with him to appointments, you may notice he's not very forthcoming. It might be awkward for you to raise it in the moment, but that can be a very good idea for you to raise that, hey, by the way, I've observed something different than what he just told you. Clinicians are allowed in law to collect information from you, caregiver, if they cannot get timely, accurate, or complete information from the care recipient. So in that moment, you might say something like, I have a different opinion, or I've been observing that he's been in excruciating pain for 3 days. He hasn't eaten and he's not able to walk. So even though he didn't say that, you're with him, you're sharing that information, the clinician is allowed to accept that information from you. But please note, there are circumstances when a capable care recipient chooses to exclude you from some information or all information. And there will be times when care providers will stop sharing information if they say so. Another couple of examples I want to share, and then we'll get into some questions. Here's another example. My 17-year-old transgender child has a general anxiety disorder. When we go for healthcare appointments, I know they want me to stay with them, but I'm often made to feel embarrassed that I'm overly controlling when I tell their providers that they want me to stay with them. My child hates having to ask for me to be with them, so they just passively go without me. It makes me feel very anxious every time we have to see a new provider. Once we know the provider, I'm usually included in conversations with my child, but until they get to know us, these initial interactions can be painful. Heads up, there's no magic age when a child starts making their own decisions. The time when they make their decisions is when they're capable. And that age can fluctuate depending on the type of decision to be made and the individual child. So to be capable, a child has to have the intellectual and the maturity to make decisions. And that is decided by the care provider. So if they're capable at any age, and we usually see kids starting to have the intellectual and maturity abilities for especially simple healthcare decisions between the ages of 10 and 15. But there's no magic age. It's not 16. It's whenever the child becomes capable of making the decision at hand. So in this case, we have a 17-year-old, and that person is capable. So it really is, what does your child want to do? Do they want you involved or not? So here are some tips. If the 17-year-old is capable, they can make their own decisions, and they can decide to include you or not. Again, about everything or about some things, and that can change. They don't have to go through healthcare alone and without your support. What we want to do is encourage all care recipients to have people to support them. And that's why you're advocating to be there with them. They may need to help make it clear to the providers that they genuinely do want you involved and that there isn't any coercion. A lot of times, especially with young people, with their parents, one of the things that providers are doing is assessing to make sure that the youth really does want their family member with them. If the care recipient feels awkward about it, they can write down their instructions that they do want you to come with them. And you may want to help your child make decisions on their own whenever they can and help them have some autonomy. There may be some situations where the care provider is advocating for the care recipient to do some things alone. Last case, and then we'll get to Q&A. My 29-year-old son has significant developmental disabilities and continues to live with me as an adult and relies on me for all his physical care needs. I'm his decision maker. When he was a baby and a child, we had a wonderful support. I was considered a key partner in his care team, and I really worked well with his providers. They listened to me, and I felt included in his healthcare planning. Since he became an adult, all the coordination is gone. I'm not included in updates. I have to fight to get information we need from his specialists. It takes me so much more time and effort to gather information, and I don't feel like his providers have all up-to-date information. The transition from the children's system to the adult system has been extremely disappointing. I have to be a strong advocate for him, but that strains my relationships with his providers, and I just want to be treated with respect. So we in the decision-making tree, in this case, the care recipient is incapable. The caregiver does have authority as the substitute decision maker. And really what should happen is you show that you're the decision maker and they involve you. But now we have to talk about the elephant in the room again. The healthcare system isn't perfect. It's not easily coordinated. The fact that you are the substitute decision maker may not be easily found on the health record. And every single time you may have to reintroduce yourself. And that's just part of the brokenness of the healthcare system. Tips for you, where he has always been incapable, there's never going to be a POA. He's never, even though he's 29, is never going to have the ability to make his instructions to appoint someone. And unless he has a spouse, you as the parent will automatically be his substitute decision maker. Now, it's possible he has other parents and they may also be decision makers for him, but you as the parent would be the substitute decision maker. And when you say that, and your child is not able to make his own decisions, the care team, the providers, must follow your instructions. You are the substitute decision maker. So you would automatically be found at number 5, and you can make all the decisions as a substitute decision maker. So I'll just pause there. And I do have another scenario, but I want to just make sure we get some Q&A going. So do we have some questions, Hannah?
Yes, we do. And thank you so much, Kate, for sharing all of that information and the scenarios that I know I learned a lot, and I'm sure everyone else that has attended did as well. And yes, our chat has been quite busy with questions and comments, so I've put some together here for you. So the first one is, what are some alternatives to guardianship for adults without capacity? So,
Yeah.
to be a substitute decision maker in health or personal decisions, do you require that power of attorney for personal care or guardianship?
So, for healthcare and privacy decisions, so let's talk about a care recipient who has had an acquired brain injury and they're not able to make their own decisions. And that's going to be a permanent condition. To make healthcare and privacy decisions, if there is a guardianship that was issued, that person will have top ranking. But let's be honest, that's an expensive process to go through. So, for healthcare and privacy decisions, that automatic list of substitute decision makers comes into force. If the person before their acquired brain injury had issued a document called a power of attorney, that document comes into force. But let's presume that doesn't exist. Then it goes to the automatic list of family. Is there a spouse or partner? If not, are there children for this person? Are there parents for this person? If not, are there siblings for this person? And again, then there's that any other relative. Now, if there is no one who is able or willing to come forward to be a substitute decision maker, the public guardian and trustee would make decisions. That's not the case so much with property decisions. There's a more formal process that you have to go to, but that's a different webinar.
Well, thank you for that. That's very helpful. And we have another question here about, is this information applicable provincially or federally? And if provincially only, how does it apply across provincially or internationally?
Yeah. So for the most part in Canada, the rules are similar but not identical. So I am only talking about an Ontario circumstance. I think you will find in Canada, the rules are very similar, but they're not identical. So if you're not in Ontario, I would recommend that you get webinars in other jurisdictions. Certainly internationally, there can be big diverse kinds of approaches to decision making. So I would say this is very much an Ontario webinar.
All right, wonderful. Good to know that this is provincially applicable. The next question, we've had a few different iterations of this question, is my husband and I have our POA and will set up, drafted by a lawyer and all that. But I know of people who are using the online kits to do a POA. Is this an acceptable option for people who can't afford lawyers' fees?
Yes, generally speaking, yes, but it has to meet certain criteria. So, and again, I can't give legal advice off the fly, and I don't know what all those kits look like. So, generally speaking, yes, you can do online kits, and especially if it's a Canadian and an Ontario kit to identify someone who to be your power of attorney for property or personal care. Most of the time that is correct, but it has to meet certain criteria like who can sign it and who can be included in those documents. So there are some rules. It's under the Substitute Decisions Act, if you want to look, but you want to look for a kit that says this is related to Canada, this is related to Ontario. But yes, you can generally do it.
All right, fabulous. Thank you for that. Another question we had come in was, even if someone is incapable to consent to treatment, are they able to consent to disclose information?
So the two things usually go together. So if you're not able to make your own decisions about treatment, then all of the information about that treatment decision goes to a substitute decision maker. So generally speaking, if you're not capable to make treatment decisions, you're also not capable to make privacy decisions. But let's just also remember, you can be capable of some decisions and not all decisions. So it's possible that someone might not be capable to make decisions about psychiatric medication. So all the privacy decisions about that psychiatric medication and the decision about it would go to the substitute decision maker. But that person might be able to consent to counseling. So the information about the counseling and the whole decision to have counseling would still reside with the care recipient. So normally privacy connects to the ability to make your own treatment decisions. Those two things go together, and you can be capable of some things and not all things.
Really great to know that
Yeah.
the capability and not capable is flexible in all the different
Yes.
situations. It's not a one-term blanket
You
thing
know,
for health.
so here's the thing, that it's not an on-off switch. Okay. It's more like a dimmer. And so for some people, their dimmer is all the way off and they can never make decisions about anything. But for most people, and so for some people, the switch is all the way on. But for lots of situations, they get a dimmer switch and they can make some of their decisions and not all. And is that hard for caregivers? Yes. But that nuance is part of the law.
Absolutely. And another question here is about, is a power of attorney stronger than an SDM?
Okay, I love this. Okay, let's go back to what is an SDM. An SDM is the legal term for somebody who can make a decision. A power of attorney is one kind of SDM. It's the second most powerful type. So the only type of substitute decision maker more powerful than someone who holds the document, a power of attorney, is a guardian. So yes, because there's so few guardianships where someone has gone to court and it's a big deal to have a guardianship, guardianships will come in when someone has their parents have died when they were children. There will be circumstances of guardianship when someone has a significant intellectual or developmental disability. So that circumstance, there will be guardianships. There are guardianships, famous ones are Britney Spears, or someone who has a lot of money and then they have concerns about mental wellness. That can be, it's called conservatorship in the United States. That has guardianship. There aren't very many of those. So the highest power otherwise is a POA. But then what we hear sometimes is, who's POA? No, actually, we're looking for who's the substitute decision maker. And if someone hasn't issued a power of attorney document, then there's still a list. But yes, a power of attorney document is the second most powerful type of substitute decision maker.
Wonderful. Thank you for that. And I have one more question here, and I know we're running out of time. There's lots of comments, and thank you everyone for being here. In the case of an involuntary separation, will the spouse still be a spouse under the SDM list?
Kind of depends what we mean by an involuntary separation. So if people are traveling and they just happen not to be together, yes, they would still be spouses or partners. If they had a argument and they slept apart for a few weeks, that is not necessarily going to remove decision making from that individual. And how would, providers don't have forensic investigation licenses. Like, they don't know what's going on behind the scenes. So the only time it will arise that a spouse or partner would be challenged, whether they continue to meet that, if someone else says so, right? The children say so, the best friend says so, the siblings say, no, they're apart, then that will come up. And that's when providers sometimes need legal advice, like, who is this still allowed? But the law says that if they're no longer living together because of a breakdown of the relationship, then they no longer meet that definition of spouse. But there can be very challenging circumstances, and it will depend on what happens. Yeah.
And it looks like some folks in the chat said that this is they had meant it towards long-term care, and one spouse being in long-term care, and they've been separated from their other spouse, maybe due to financial reasons or just due to the living situation.
No, that's not a breakdown in the relationship. So that's a great example, right, of your health condition has meant that you've been living separate and apart. So the rest of what the law says is spouses living separate and apart due to the breakdown of a relationship. So if you happen to be living in two different long-term care homes, that does not deny the other person their spouse or partner relationship. If it happens that you live in other countries or you live in other provinces and you are still together, but you don't cohabitate, that does not deny you your spouse status or your partner status. Yeah, that's great clarification. Thank you.
Thank you for that. And just a final question, because it kind of touched on the last of what you were saying there, is will hospitals or healthcare providers work with SDMs when there's a difficult time change? Say there's a 12-hour time change between where where the SDM is versus where the person is receiving healthcare services.
Great question about what means for a substitute decision maker to be, quote, available. So that's a tricky situation, and it really does depend on the length of the healthcare relationship and what the timing of the decision making is. Yes, in many circumstances where like if your care recipient is in Ontario and someone else is living in 6 hours time difference or what have you, many times healthcare providers will try to communicate out of hours. But that's imperfect, elephant in the room. We can't ask providers to, get up at 2 a.m. so that they can have a conversation because that's when you get off shift or that's when you come online. Some will be willing to do that. You can absolutely ask, but that is sometimes where we find substitute decision makers are not available because they are not able to be involved due to different time zones, etc., or technology availability as well.
Right, great to know. Thank you so much, Kate, for all of the information you provided during the presentation and for all of these questions and answers. I know it's been helpful for me to understand better, and I'm sure everyone that was here today also has a better understanding of the legal information that pertains to caregivers. And I want to take a moment to thank all of you who attended here today too. We really appreciate you taking the time out of your busy days to join our webinar.